So it's my fault we're 4 minutes tardy. I'm used to 9 o'clock, 8:30's fine for schools, but not for courts. We have 3 cases on the docket this morning. First one is 1524 quadruple 07, Mike Morath in his official capacity versus Kingsville ISD et al. Who's present for the appellant?
Beth Boozman for Commissioner.
Ready? And defendant?
Your Honors, David Campbell here for the appellants.
Good to see you again.
School districts, good to see you, Judge.
Yeah.
And Your Honor, David Thompson representing the lead plaintiff interveners below in the trial court.
Okay, how are y'all splitting time?
Your Honor, I will be taking 7 minutes and speaking first within the employee's time, and then Mr. Campbell will take 13 minutes.
Okay.
And address other issues.
Count on the bailiff to enforce that, and you're splitting your time, I assume?
Yes, I'm reserving 5 minutes.
Okay, you may proceed.
Good morning, may it please the court. By issuing accountability ratings, the commissioner would be following, not violating, the education code. First, the commissioner's authority to issue ratings is not contingent on some sort of advance notification of what's going to be in the accountability manual. Second, school districts cannot demand that the commissioner set standards so low that they can earn an A no matter how poorly they perform. And third, the STAR test has been determined to be valid and reliable by an independent third party. For those reasons, the court should reverse the temporary injunction, render judgment dismissing the case, and allow the public to finally see how their districts and schools have been performing. I'd like to start with what I'll call the lateness claim, the idea that too much time has passed that we can't have ratings because of when everything happened during the school year. So I want to make clear, first of all, that the commissioner did adopt the accountability manual during the course of this litigation. There was no contention that that was an ultra vires act. They made no attempt to stop him from doing that. So we have the manual, we have the data. And the only question before the court is, can we put those two things together and issue accountability ratings? And their argument to the contrary hinges on this idea that school districts are entitled by statute to some sort of early notice of what's going to be in the manual so that they can tailor their educational offerings to the students and the programs that will sort of maximize their ratings. But that's simply not there. I imagine they will walk you through the oral argument exhibit that they filed, and looking at the first page, the first line, that it says they need to adopt and announce the accountability rules by the start of the school year. There's, just to put it bluntly, that's language that they have made up. That's nowhere in Chapter 39.
But
And-
wouldn't that be a good idea?
I mean, that would certainly be helpful, and that's actually usually the case. Because the commissioner holds standards steady for 5 years at a time, they know when the school year starts what they're going to be aiming for. But this year, for reasons we've detailed in our brief, because he was raising standards and they were making statutorily required changes to the STAR test, there was just a delay. So this year was out of the norm. But for the most part, yes, they do have that kind of notice. But I would also say they know from statute that the prime drivers of their ratings are going to be the STAR test, the CCMR rate, and the graduation rate. They know that. There's nothing stopping them from doing the best that they can in those 3 elements in the first place.
I had a question about the Morath versus Lampasas case.
Yes.
So in that case, the court found that you could interpret a legislative directive that doesn't have a time frame to encompass a reasonable time frame. Does that affect things here?
Oh, okay, so those were, I think, yes, I was thinking of the second part. The first part of the decision said, yes, you need to act, there was no deadline, is what it was, and so they interpreted, well, act in a reasonable time, because we were trying to decide there whether or not a school was, or a district was actually gonna vote on an annexation or detachment petition, and they just never did, and so the assumption was at some point in time you get to say, you've said no, and we can move on. And that's different than what we have here when the commissioner is prepared to issue these things. 3 months late is not that late, honestly. I mean, the question the court essentially asked in the second half of Lampasas when they were discussing whether or not the ALJ's failure to reach a decision within 180 days stripped him of the authority to do that. The question is, would you prefer a late decision or no decision? And when we look at the statutes here, it's clear that the legislature would prefer late ratings to no ratings, because the ratings are a key part of the accountability system. We need to know how schools are doing if we're going to invest the resources that we need to help them along, if we need to intervene. That requires multiple years of poor ratings in a row. If we just don't have those ratings, the system doesn't make a lot of sense. And so, sorry, I want to go back sort of to that first point of whether or not they're entitled to those early ratings. While it would be helpful, yes, it is not required by statute. Instead, section 39.0541 states that the commissioner may adopt indicators and standards, quote, at any time during a school year, end quote. So he can wait until the end of the school year when they can't make any more changes and adopt his accountability manual and fully comply with chapter 39. And
I know there's some argument between the parties as to what the provision means that, you know, you have to be able to get an A.
yes, yes.
You know, I know that one interpretation of that is it can't be on a curve. But the other interpretation is, what if you adopt the manual late, and then under the new guidelines, no one gets an A? Is that a problem under chapter 39?
No, Your Honor, I would say not, because what we're talking about in section 39054B, which is what you're referencing, is the commissioner must use a method that makes it mathematically possible for everyone to get an A. And so the method is whether or not you're using, for example, a curve where we map everyone and then just, you know, chop off the bottom part, or whether you're using these cut scores that would enable them to get an A if they perform well enough. And so the plaintiffs are interpreting that to mean you must set standards that make it factually possible for everyone to get an A. So under their theory, for example, just under the way it's currently set up, we always use the prior year's CCMR rate, because that information continues to develop over the summer, so we can't include it in the current year. That's just what he does. But under their theory, if there's a school out there that bottomed out on their CCMR rate, got 30%, that's what the commissioner would have to say an A is. Under that theory, if the commissioner knew what the STAR results were before finalizing the accountability manual, then he's got to set it at the very bottom in order for everyone to be able to factually possibly get an A. And so that's not what's required. If we look at the surrounding context, for example, he's supposed to assign A through F, so there are certainly schools and districts that are going to get less than an A, and he is also supposed to modify the standards to close achievement gaps and make sure that Texas becomes a national leader in post-secondary success. He can't do that if he has to wait and set everything at the bottom in order for everyone then to get an A. He needs to be able to push the school districts forward. And so that's just the result of their interpretation is whatever information he has, if he has that information, well, he's got to set it at the bottom of whatever he knows already. And that's not what this statute was required.
So what changed for the 21-22 year? The school districts say, such and such a district went from an A or a B to an F. What made that happen?
For the manual we're talking about?
Right.
Yes. There were two changes. Number one, there were statutorily required changes to the STAR test, not to make it more difficult, but to make it more reflective of what you do in the classroom. So they weren't allowed to use more than 75% multiple choice questions. So that just took a while to work through the system. And then the second change was that it was time to increase standards. The commissioner had held standards steady for 5 years so that, as they put it, schools could compare apples to apples. They could look at what I did this year and what I did the next year, and those would be judged by the same standards, instead of the past where he'd sort of cranked it up a little bit every year, and so you were always sort of trying to play catch up. Held it steady for 5 years, and it was time to raise standards. So you had a change in the STAR test, and you also had time to raise standards. And so that made the accountability manual this year. That's why it was delayed, but that's also why it was different than the prior year's manual.
And can school districts or individual campuses appeal their ratings?
Under section 39.151, yes. It's usually sort of a mathematical, did you do all of the math correctly to perform the ratings? It's not usually a constitutional challenge or anything like that. But there is a process that districts can go through if they think something has been, incorrectly done with their ratings.
Well, that's what perhaps I shouldn't have done this, but I'm thumbing through the statute yesterday, and it seems to say 151, the commissioner provides a process for schools to challenge academic or financial accountability rating, and if they have an opportunity to do that and don't, they cannot file any other proceeding. That seems to say we can't do what we're doing.
I guess that,
I'm just.
Sure, and it sounds
School district may not challenge an agency decision relating to an academic accountability rating, including a decision relating to determination of consecutive school years unacceptable performance in another proceeding if the district or school has had an opportunity to challenge the decision under this section. So if they didn't challenge it under 151.
well, they don't have the ratings yet to challenge. And that's, I think, the problem is that assumes
That's
they're
because-
challenging a rating they have been
That's because they
giving.
got the trial judge to refuse to release them.
Yes, Your Honor. And so once they
So
are.
that's all you have to do to be able to file in court. You skip the administrative proceeding, just get a friendly judge to enjoin the proceedings, enjoy the issuance of the ratings, and therefore there's nothing to appeal.
I think the commissioner would not advocate for that understanding, yes. But as I understand 39.151, if those ratings are issued and they believe something was wrong with their rating, that is what they would use. But we do think there is a problem with being able to come into court and raise claims. And then, I mean, we are a year after these ratings should have come out, and the public still doesn't know. So yes, we do think that these kinds of lawsuits, they need to be looked at very closely. And again, with respect to just bring it back to sort of their lateness claim, the question is, would the legislature prefer no ratings to late ratings? And there's nothing in the statute that says, that ever takes away the commissioner's authority to issue ratings. There's no statute that ever says, if X, Y, and Z happen, you can't issue ratings. Instead, it's understood that ratings are gonna come out.
And are those the only choices here, like in terms of any type of judicial remedy for the late release of the rating? Is it either no consequence at all or barring the issuance of the rating? There's nothing.
I think so, Your Honor, because we are in the ultra vires world, and so, now I don't think barring the ratings is an appropriate ultra vires remedy, so I'll get to that, but, yeah, because we're dealing with sovereign immunity, the remedy is up to the legislature. So that's why they have to fit within this ultra vires box. And that says, you can order them to comply with the law in the future. So again, if we had that statute that said no ratings if X, Y, and Z happen, then we could, and X, Y, and Z are at issue, that's when the ultra vires case would kick in. But we don't have that statute. We don't have a statute that makes ratings contingent on the timeliness of the accountability manual. So if you are going to issue an ultra vires order, it would be comply with the deadlines in the future, but you couldn't then attach new consequences, which are, and don't issue ratings for last year, to any sort of past failure. You can only say comply with the law in the future, that prospective relief.
What's the remedy for a district if the new manual comes out and under the new manual, new guidelines, every district gets an F?
I think that the legislature would most likely have something to say about that. I mean, honestly, that's probably how it's going to work out. The commissioner testifies before the legislature with great frequency, and if that were the case, then I think they would be calling him in. But the reality is, even by statute, the commissioner works with stakeholders. He talks to the public, he talks to the districts, he does all of these things when coming up with the accountability manual. So it's not as if he's, it's not a black box that he's sitting there and just working in. It is publicly discussed. And I mean, there are 1,200 school districts, there's gonna be 1,200 opinions as to what that manual should look like, but the legislature has given that authority to the commissioner to decide, here is where we're gonna draw the lines, here is how we're gonna measure success, and so he has not, fortunately, set everyone at an F, but I think, but because that's what's realistic. We want school districts to succeed, and we want to set reasonable standards that they can meet, but we also, need to push them forward.
Could I ask a question about the STAR test issue?
Yes.
Are there any other cases that address when an entity is independent in a statutory scheme like this?
I haven't, the closest case that I was able to find was the State versus Volkswagen case, 692 Southwest 3rd, 467, because I didn't get that in my brief. That was when, I admit the circumstances were different, but the governor had to appoint a couple extra members to the Supreme Court because due to recusals, they couldn't get a 5-person majority. And so there was an argument that they also had to recuse because they were appointed by the governor in a case that the state was involved in. And so there were due process and ethics concerns, and the court said no. They had no stake in the case. Merely being appointed by the governor did not mean they could not exercise independent judgment. And so that's what we have here. Their main argument against the TTAC, the Texas Technical Advisory Committee, is that it is called by the commissioner and that they are compensated. But anytime you're going to have an independent third party come and look at this test, you're going to need to ask them to do that, and you're going to have to compensate them for their time.
Before your time runs out, let me ask you about 542.
Oh, yes, I definitely wanted to address that.
So school year is September 1 to August 31 or something else?
There's actually no statutory definition as to when it ends. I would have wanted that, but usually we're looking at the end of May, early June, honestly, for the end of the school year.
So the summer is not part of the school year?
I don't think it's usually considered part of the school year.
So doesn't that, if it says, 542 says you're going to give a simple, accessible format report, it explains the measures, methods, and procedures that will be applied for that school year. Why does that not have to happen before, that has to happen before May?
Yeah, yes, if I could finish, my time has actually
Sure,
expired.
absolutely.
Yes. This document, this is essentially a handout. It is taking the 300-page accountability manual and putting it into something that is simple and accessible that the districts in subsection B can then give to the public who wants to understand how the accountability system works. We gave them that document in March. That's 27-0203 of the record. Now they can pick at it, but we're like, it's a 300-page manual we're squashing into a handout. So there's going to be some details that are left out. And if there was any other questions, the commissioner provided a lot of extra information during the school year that we've highlighted in our brief. So unless there are further questions, I will reserve the rest of my
Thank you,
time
Ms.
for rebuttal. Thank you.
Good morning, and may it please the court, my name's David Thompson. I'm representing the appellees, plaintiff interveners below 62 school districts responsible for educating approximately 1.2 million children. I'm going to take a few minutes, and with the court's permission, I'd like to address one issue. Mr. Campbell will take a majority of the appellee's time and address other issues. The one issue I would like to discuss with the court is the commissioner and the Texas Education Agency's conscious and pre-planned decision to disregard statutory constraints on the commissioner's rulemaking authority. Now, at the very outset, we hope it is absolutely agreed that agencies cannot confer on themselves rulemaking authority. Rulemaking authority is given by the legislature. Agencies must exercise that authority within those constraints. I would like to call the court's attention to 3 undisputed facts in the record. Number one, the agency's own witness, the Associate Commissioner for Accountability, testified that there was absolutely no statutory requirement to update the accountability system for the 22-23 school year. That was a discretionary decision that the commissioner simply chose to do. It was not in furtherance of any legislative requirement. That's fact number one. Fact number two.
So if an agency decides they're not going to do anything, that's a rulemaking procedure?
No, Commissioner, I'm sorry, Your Honor, I will get to the agency's adoption of rules in just a moment, but take that fact. Fact number two, that decision was actually a departure from 40 years of history in Texas. Every time we've implemented a new test in Texas, and make no mistake, the STAR is the same name, but it is a new test. And I believe even the commissioner has spoken publicly to that. Without exception, in Texas history, when we implement a new test, we implement it in 1 year, and then the next year, once you actually know how the test is operating, you make the adjustments to the accountability system. The 22-23 year is the only time in history that the agency attempted to implement a new test and simultaneously change the accountability system without knowing how the test was going to operate. And frankly, we believe that decision probably contributed to the agency missing virtually all of the statutory deadlines. And then the third thing I would like to call the court's attention to,
So where does that rule come from?
here are the rules. If you look at 39054, we'll start there. 39054A is actually the statute that says the commissioner will adopt rules for A through F grades. But, Your Honor, look at the first 6 words. Except is provided in subsection A4, the commissioner shall adopt rules. So A4 is actually a limitation on rulemaking authority. What does A4 say? A4 talks about circumstances that are beyond the control of districts and campuses.
I'm sorry, say that again.
Subsection A4 specifically addresses circumstances that are beyond the control or outside of the control of districts and campuses. It makes perfect sense. How would you hold someone accountable for something that they literally have no control over? That is actually in statute a limitation on the commissioner's rulemaking authority. Now, obviously, in this case, again, it was an agency decision to change the test and the accountability simultaneously. I think they overreached. I think that caused a lot of the deadlines to be missed. That wasn't a mistake made by students. It wasn't a mistake made by teachers or campuses or principals or parents or the legislature. That was a decision made solely by the agency. Second limitation on the agency's rulemaking authority. And this is not simply a timeline that the agency can say, well, we like it or we don't like it. 39051 is about adoption of indicators and standards. That's rulemaking. That's not simply publishing something by a date. That is authority to adopt a rule. And there are 2 constraints in statute on rulemaking authority. One, it has to be during the school year, and if you look at the legislative history, in 2017, that initially said by September 30th, and it was during the legislative process that it actually was developed to say adopt during the school year. That is a
Doesn't it
constraint.
say at any time? I mean, couldn't
At
they do
any-
it on the last day of school?
You could do it at any time, and again, that was a legislative decision, but it also has to be, there's a second constraint, it has to be before districts are evaluated. So there are 2 constraints. It is undisputed in the 22-23 school year, no indicators and standards were ever adopted at any time during the school year. The commissioner did not adopt indicators and standards for the 22-23 school year until we were over 3 months into the next school year. That is outside of his rulemaking authority. The agency's argument appears to be,
So I hear you, but maybe I missed it. I didn't see anything in anybody's briefs about this being subject to the APA rulemaking procedures. Did I just miss it?
we are not arguing that it violated the APA. We're arguing that it's simply outside of his authority conferred by the statute. We're not arguing that it was a procedural violation of the
Because that wouldn't
Administrative
work at all.
Procedures
You gotta
Act.
have public comment and all this stuff.
Correct.
The legislature didn't suggest
That's
that.
not our argument. Our argument is he simply did not have the authority to adopt the rule in November of '23. Think of this analogy. It's fall, it's football season in Texas. 2 teams play a game on Friday evening. Teams leave and go home. 2 weeks later, the refs get together,
Skip to the end of the ball game.
decide on the rules, decide field goals are worth 5 points instead of 3 points, call the teams 2 weeks after the fact and tell them who won or who lost. That's functionally what happened here.
Thank you.
Thank you.
Mr. Thompson.
Mr. Campbell.
I'm sorry, you're Mr. Thompson. Mr.
I'm
Campbell.
Mr. Thompson.
too many Davids, I guess.
Ah, so where is the time deadline for,
You aren't anxious to get out of here, are you?
I mean,
We're,
no, not your time deadline, the time deadline for the commission.
understood. So, actually, let me jump ahead to that, Chief Justice Brister. I'll scrap my intro and just jump straight to the meeting. If you turn to tab 1, I try to just summarize the way that we have tried to explain in our brief how the legislature meant for this to work. Justice Ferris, you had mentioned, wouldn't it be a good idea if the commissioner adopted and announced these rules ahead of time? Not only is it a good idea, it's a good idea that the legislature had. And so if you look, and you have to read the statutes together, right? I mean, this is not a case about a single statute, a single publishing deadline. It's a case about the statutory scheme. So, Justice Brister, if you start in Education Code 39.054, as Mr. Thompson mentioned, that gives the commissioner 2 options. It's a fork in the road. Either you go to subsection A4, which allows the commissioner to assign not rated, which he's done before, or you opt into the rulemaking regime. The rulemaking regime starts with, and I've highlighted in blue, that the commissioner shall adopt rules to evaluate school district campus performance. Now, to your question, how do we know that that means before the school year starts? If you go to 39.0541, that says anytime during the year you can adopt indicators and standards. So which school year? Well, keep going. 39.0542. Each school year, the commissioner shall provide each school district a document in a simple, accessible format that explains the accountability performance, measures, methods, and procedures that will be applied to the school year. Now, I understand, well, let me take a step back. I suppose there could be an argument about whether that means that document could be adopted sometime during the school year to provide all the measures, methods, and procedures. Doesn't make a lot of sense, but I guess that argument could be made. In this case, the only document that does that is the accountability manual. That's why I put 39.0541, 0542, and 054 together, because really I think what the legislature is trying to do here is say, Commissioner, adopt by rule an accountability manual that adopts indicators and standards and explains the measures, methods, and procedures that will be applied. Now,
Could you help me, though, with this language in 0541? It says at any time, which seems to indicate that he could do it on the last day of school, and there's no harm, no foul. I mean, the fairness almost seems like a due course of law argument, which you may not be able to make here, and I don't understand this to be a due process case, but I mean, when the legislature says at any time, you know, maybe nobody wants to play Calvin ball, but if the legislature says we get to play Calvin ball, then don't we get to play Calvin ball?
right, so I think if we were in that situation where the legislature hadn't given us rules, then we might have a due process challenge. But let me just stick with the statutes, right? So indicators and standards are what is measured. If you read the statute, the legislature has given certain indicators and standards that must be used and given the commissioner some discretion to adopt other indicators and standards. But telling us what is measured doesn't tell us how it's measured. That is the methods and procedures. Now, I want you to just take a step back from the statute, go back to law school. Imagine if the law school had a rule, which I think most probably do, that said each school year, the professor shall provide each student a document in a simple, accessible format that explains the grading, measures, methods, and procedures that will be applied for that school year. I think everyone would read that to mean before the semester starts, students are entitled to know how the professor is going to grade them. And if a professor read that statute,
Not if it's at any time during the school year. That could be the last day.
so the at any time during the school year is for the indicators and standards. That's just the what is measured. So at any time during the school year, the commissioner can adopt indicators and standards. But then the question is, okay, now we've got new standards, we've got new indicators. How will they be measured? And that's where you have to go to 0542 and say, whenever the commissioner adopts indicators and standards, each school year, the commissioner has to provide a document that explains how those measures, methods, and procedures will be applied for that school year.
And that, I mean, there's some logic to that, for sure. But I mean, I guess what I'm struggling with, and maybe you can help me, is we're here on ultravirus. And so why wouldn't the option be to, you know, try to force the issuance of that at an earlier time versus trying to stop the release of the grades after it's in hand.
So, Justice Ferris, I think obviously that would be ideal. The problem is that this school year, it was like boxing with Jell-O, right? I mean, the standards kept changing during the school year. Now, my friend on the other side mentions this March document. If you go through the record, and there's a lot of testimony about this, there was one standard in September, and then later in January, there's some changes to it. Then in March, there's a new standard. There's even testimony from Ms. Tian, I don't have it in front of me, but there were even some representations the commissioner made about things that wouldn't change, like graduation rates, that actually did change. Justice Brister, you had asked about some of the changes. If you go read Dr. Blaine's testimony, it's pages 151 through 153 of the transcript. She described some of those changes that were made. And there weren't just two, there were many, many changes that were made. There were some,
Let me skip to the end. We've got a limited amount of time here, 151 and 53. I'll make a note of that. So 2 questions. First, on my 151 question. I mean, what part of that, you're here on a temporary injunction. To prevail on a temporary injunction, you've got to have irreparable harm. How can you possibly have irreparable harm if there's an administrative procedure where every one of your clients can challenge the ratings they get?
so there are 2 answers to that question. And I couldn't, because I just have the written document, I couldn't find the exact page, but in Intervenors Exhibit 15, there's a slide presentation from the commissioner that explains the appeals process. And what the commissioner has represented to school districts is that in that appeals process, the appeals process is not a permissible method to challenge, a permissible method to modify the calculations adopted by the commissioner by rule. Now, of course, here we didn't have a rule to challenge. That rule, my friend on the other side mentions it was adopted. It was adopted after the injunction was entered in this case. Certainly never during the school year and never while this case was being litigated in the trial court did we have a rule. But I'll see if I can maybe file a supplemental brief with the precise page, but I think it's Intervenors Exhibit 15. So that's one thing.
Okay, what's the other one?
Second thing is, Justice Brister, the commissioner has often taken the position, and at times successfully, that once he has done something, then if you challenge it, you can't challenge it because the ultra vires challenge would be retrospective in nature. And at least one court has agreed with him. If you look at the Third Court of Appeals opinion in Progresso ISD, I think it's Morath versus Progresso ISD, the court said, assuming arguendo that the commissioner did commit an ultra vires act, nevertheless, he's already done it, so it's final, it's over, and therefore King's X. So it's a classic, heads I win, tails you lose type argument.
But that was on the ratings, an appeal of the ratings under the statute, or was that something else?
That was, no, it was something else, Your Honor, Justice Field. I think that was, that had to do with attendance at a school and how that was being calculated. So, but that's the concern for a client.
Sure. There may be limitations on what you can raise in a challenge to the accountability rating for your district. But if it says, if you've had an opportunity to do that, you can't do anything else, you can't defeat that by running into court first and preventing the issuance of the ratings. That just doesn't seem right.
I understand the argument, Justice Brister. I think if we did have an opportunity to go through that process, which has never been argued by this other side, so we've never briefed it, and I understand.
It's unfair, but it's immunity, and immunity is unfair.
I understand. I'm on the other side of that argument a lot of times. And so, all that I would say, Justice Brister, is if we had an opportunity to exhaust administrative remedies, obviously we would have done so. But because the commissioner had represented that we couldn't, based on that exhibit I mentioned, it brings to mind that, I think, the Mosley decision from the Supreme Court that you can't, on the one hand, I think in that case, I forget what the agency was, but it was an agency that basically told someone, here's your deadline to appeal. It turned out that that wasn't the deadline to appeal. And then they tried to argue later, well, you shouldn't have taken us at our word. So I think that there would be a due process problem if the commissioner were able to, on the one hand.
Is there anything in the record saying you all could not, if you'd allowed the ratings to be issued, that you all could not challenge them and straighten them out? My problem is irreparable harm. And if, we're all afraid we're going to get Fs and this, that, and the other is going to happen, but if you can reverse it and get a D or a C or a B or whatever you're gonna get, how can you until you try, how can we possibly know there's irreparable harm to your district?
I think there are 2 or 3 answers to that if I can remember them. We'll see. I mean, one answer to that, I think, Justice Brister, would be if the ratings were assigned, if you go through the superintendent's testimony, there were 4 superintendents that testified, each testified about the harm that occurs once the ratings are released. So if the ratings are released and then you can challenge them and maybe a year later it gets changed, the harm has been done.
But the harm is that people will believe them and I don't know, move their kids to a private school or something else, or the staff will leave, which was, as I understand it, one of the purposes of the accountability ratings. I mean, why are we publicly publishing this school district or campus is an F if we want people to stay there? The legislature wanted people to know so they could vote with their feet. Why? I mean, who is the rating system for? Is it for parents and children, or is it for schools and school administrators and school teachers? It can't be the latter.
I completely agree. And so, Justice Brister, that is why the school districts in this lawsuit are so concerned with the ratings being accurate and not having a gotcha. You know, I can remember back in school, I don't know if they do this anymore, but they used to have the presidential fitness thing that you would do, sit-ups, run a mile, whatever. And as a kid, I had asthma. So I had trouble meeting the mile time. So during recess, you know, when other kids were playing tag, I would run to try to get to that cutoff because it wasn't easy with my inhaler in my hand. And at the end of the year, I managed to make that cutoff. And I can't imagine how I would have felt if at the end of the year, after working so hard to raise to that standard, someone had told me, actually, it's not 8 minutes. We decided to make it 7 minutes, and you should have just tried harder.
It makes perfect sense for the legislature to say that. The question is, where did they say that?
So we provided the statutes where the legislature said that, Justice Brister.
Well, I want to follow up on this question because it's crystallizing something for me. Isn't the problem we've got here that if you had filed suit saying, wait a second, you haven't made this rule yet and you haven't done it timely, court, make them do it timely. That's the ultra-virus claim. But if you wait until after the manual is done and all that's left is to issue ratings, then don't you run into the problem that what's the irreparable harm because you have a means to challenge the actual rating? In other words, isn't the problem we have here in some ways that the ultra-virus conduct is a moving target, and one of those things has some prospective relief you could get, one of those things doesn't? Does that make any sense at all?
I don't know, Justice Field. I mean, the way that I see it is the reason that we didn't file this sooner is I'm sure if we had filed this earlier in the school year, we would have heard it's not right. The commissioner is still working on the rules because that's what the commissioner was telling us. Behind tabs 4 and 5, you have a letter that school district sent back to the commissioner trying to get this worked out. You have a letter from legislators trying to get this worked out. So I think that the problem was that school districts were trying to get the commissioner to tell them the final rules. They didn't want to bring this lawsuit. It was a difficult decision. And so I don't think, again, this is a heads I win, tails you lose type situation where I don't think you can force people to predict that the commissioner is not going to comply with this statutory obligation.
Last question. Why isn't the Technical Assistance Committee an independent agency? Argument in the briefs was, well, they're appointed by TEA and can be reimbursed. I guess they're not paid staff, they just, reimbursement of expenses?
So they actually are paid.
Okay.
They are paid something, we
So-
don't know how much.
So, of course, every appellate judge in Texas is paid by the state. And the majority of us, or in fact, all 3 of us, were appointed to this court. So are you saying, ergo, we are not independent? And in fact, almost all the judges in Texas are not independent. That can't be the test, whether you're appointed by somebody in government and paid by the state.
I feel like I need to read him as right.
Yeah.
I won't take the 5th. No.
Any other way to test independence other than those? Because that sweeps too broadly.
Yes. So Justice Brister, three things to say to that briefly. One is,
I would not have expected anything less than 3.
one would be this, that the statute specifically says an independent entity, right? And so it would be one thing, we're not saying that TEA can't hire a third party and can't pay that third party to do a validation study. We know they have done that in the past. As far as we know, not since 2016. But we know that they could do that. The problem with this committee, and one of the arguments, the first argument we have made, is that it's not independent because this isn't an entity that is out there. It's an entity that TEA has created. They chose who was going to be on it. They paid them, yada, yada. You have that argument.
Right.
The other thing that we have argued, and if you just look at, I think it's behind tab 2 of the bench book exhibits that I gave you, it's really a statutory argument. Because honestly, when this committee came up in the hearing, no one knew who this committee was. There's not much out there about it. We know the individuals on it, but we don't have minutes. We don't know how often they meet. We don't know what happens at those meetings. And that's not surprising because when you look at 39.02302, which is behind tab 2, you see that the legislature has said the purpose of this committee is to advise the commissioner and the agency regarding the development of the test. So it's not just that they're not independent, it's that the whole point of this agency is to be this entity is to be an entity that TEA gathers to help them develop the test. If you look at
Tell you what,
39,
Since you're gonna file, we need to move on. Since
Okay.
you're gonna file a post-sub letter anyway on 151, why don't you put your other arguments in there?
I'd be happy to, Your Honor.
Thank you.
Thank you for your time.
Ms. Clussman?
May it please the court. So we're not contesting that the commissioner did not adopt the accountability manual during the school year. Obviously, that happened outside the school year. The question for the court is, so what? Does that mean that he can no longer issue accountability ratings? Is his authority to do so been removed by statute? Or can he still, then Judge Gorsuch's word, better late than never principle, still issue accountability ratings even though they are after the time period the legislature originally
What if
envisioned?
they filed their suit a day before the school year ended and said, court, they have until tomorrow. No indication they're going to do it. That's ultra-virus conduct. Issue a mandatory injunction making them do this. What's the response to that?
I think it's an interesting question. I think the Supreme Court left open in Lampasas is if you do see that deadline approaching, are there judicial methods you can use to enforce it? I mean, the waiting until one day before, I think certainly presents some practical problems.
I wouldn't appreciate it.
But I mean, that's the argument then you have to have is if your authority would still exist afterwards to adopt the manual, and they haven't argued again that he was ultra vires to adopt the manual late, can you still force them to do it by the deadline? And I think in that case, I mean, just practically speaking, you're probably going to have to look at the next year just because doing it one day in advance isn't going to work. But that brings up a question. I mean, they knew back in the fall that this manual wasn't going to even be proposed until the spring, and his usual practice was to adopt it over the summer. If they believed they had a statutory right to that information at the beginning of the year, that's when you should have filed your lawsuit, instead of waiting until everything was done and then trying to eliminate accountability ratings entirely. I want to address what Mr. Thompson said about Section A4. That is a discretionary option. It says that the commissioner may assign not rated in certain events, for example, hurricanes or data breaches or things of that nature. So it's discretionary. It is not a mandatory thing that the commissioner
And how
must
many
do.
years during the pandemic, et cetera, have we had everybody not rated?
Sure, in 1920 and 2021, he issued not rated. In 21-22, there were abbreviated ratings. The legislature said you can get A, B, C, and then everyone below that was just a not rated. So honestly, we are looking at since 2018-19, since we have had accountability ratings. And that's going to explain why the commissioner said we're not going to, I mean, they talked about 40 years of tradition. We've been so long without accountability ratings, we need to have them now. That's why he wasn't putting this off. So again, tradition is not law. The law says that he is permitted to issue these ratings, and there is no statute that removes his authority to do so.
What checks and balances are in place if an F rating is erroneously issued?
Again, I think that's when you would use 39.151.
And what happens to the school district that's happened to, if people have left, transfer? When is the deadline to transfer to another school? My understanding is you can do it almost any time, isn't it?
I assume, I mean, I don't have any kids in the system, so I don't know when you would do that. I think most people probably try to have their kids lined up at the beginning of the school year, but you can
gotta
probably,
have an opening where you want to go, but
Right.
you can.
right.
And so, if people start transferring out, what resources helps school district in the interim for the daily funding they've lost because these students left?
I mean, that's how, you stole my thunder a little bit about, this is about the students and making sure that the students are getting their education. And so we have testimony from several superintendents about how they turned around their districts. It can be done. There are ways to get it done. But that is just one of the consequences of the accountability system, is we need to know, are these districts performing? And if not, what help do they need? And what remedies are possible, so that we can ensure that, the legislature is meeting its constitutional obligation of providing an education to the students within the state. Quickly on what we call TTAC, I think if you just look at the 3 statutes that discuss it, all of them talk about a determination that it is valid and reliable. The TTAC is supposed to help make sure it's valid and reliable, and 39023A14 talks about findings and recommendations, whether or not it's valid and reliable. I mean, this is the entity that the legislature has identified as making this determination.
Doesn't the statute require empirical data to test reliability, and if so, where is that in the record?
The empirical data, I think the testimony was that, I think of it this way, Your Honor, in the sense that the FDA sort of looks over the shoulder of people who are developing drugs. The TTAC sort of looks over the shoulder of TEA and its vendors while they're developing the test. So they watch what they're doing, they see the results that are happening, and they advise on whether or not what they're doing makes it valid and reliable. So the empirical data that they looked at is not in the record because it was not our burden to prove it. It was their burden to prove that it hasn't been done. But if the case goes further, there may be an opportunity to put that in the record. So for those reasons, we ask that you would reverse the temporary injunction and dismiss the case.
Anything further? We'll take a 5-minute break. Case will be submitted, and we'll start in 5 minutes with the second case. Call 1524, quadruple 08, Troy Thwele versus Hinojosa in official capacity. Both sides have 20 minutes. Any splitting of times?
Yes, I'll do, Karen Williams, I'll do 8 minutes, then Ms. Esquivel will do 10, and then reserve 2 minutes for rebuttal, which Ms. Esquivel.
Okay. Ms. Munoz, you may proceed.
Good morning, Your Honors. I will be addressing the APA claims against the Board of Pardons and Paroles today. Ms. Esquivel, my colleague, will follow and argue specifically the ultra-vires component. Your Honors, this is a case about the overreach of government authority as it relates to parolees who have been assigned Special Condition X. Special Condition X is a mandatory condition imposed on parolees who have been convicted of certain sex offenses involving minors. This condition prohibits parolees from going or living within 500 feet of the child safety zone, which the Board of Pardons and Paroles improperly interprets to include school bus stops. Petitioner appellant and those similarly situated were granted parole, submitted their housing plans while incarcerated with the hopes of living with their families and loved ones while out on parole.
So let's jump into the law on this. I mean, what is the evidence that the board issued a statement that said school bus stops are a child safety zone?
Your Honor, thank you for the question. The evidence is more so the conduct. If you look at the testimony at trial, emails from TDCJ, which are included in our opening brief, you will see that whether it's written, it doesn't seem to be like they're written down somewhere. It was never published, but there is a general practice of including school bus stops in child safety zones, and that practice, TDCJ has said, they've said both that they have no discretion about whether or not to include school bus stops because they have to follow the conditions that the board imposes, and they've said, again, via those emails, that that the board is who imposes this.
But doesn't the board just basically include that statutory language? I mean, they don't add "and bus stops" into the actual text, right?
That's right. So again, my colleague will will address the more specific statutory interpretation portion as it relates to the ultra-vires claim. But yes, you are correct. It is true, though, that the board is who is imposing these conditions, and then TDCJ carries it out. If I may very quickly, it may help to explain how parole works in Texas. So when an incarcerated person in Texas in a prison becomes eligible for parole, their case is reviewed by a panel of 3 members of the board. And the board only grants parole if they determine that a person is at a low risk for reoffending. In approving parole, the board also determines what conditions each releasee is subject to and then imposes those conditions. After a person is granted parole, while they're still in prison, that person then submits a housing plan, which includes a proposed address, a proposed residence, and TDCJ is who investigates that address and investigates for the purpose of determining whether it complies with the conditions that have been imposed by the board. A person is not released from prison until their housing plan has been approved by TDCJ. And then after release, TDCJ then supervises each parolee until the end of their sentence.
So why isn't this TDCJ that's in control of this? Because it seems like if the board's work is done after they just issue that language, then isn't it really TDCJ that's making the call on the bus stop?
So that's sort of the issue here. It's kind of, there's so many players here that it's a little bit confusing, but TDCJ 1 is exempt from the rulemaking requirements of the APA. The board, however, is not. The board is the proper party here, though, because TDCJ's role is limited to enforcing the condition that the board set. Again, there's no discretion. TDCJ can't decide that they are going to ignore the school bus stop. They always investigate housing plans, including the distance to a school bus stop.
Isn't the problem on the rule issue, though, that agencies interpret statutes all the time and make rules from them? And they have a rule, or a policy at least, that just basically adopted the statutory language. So if the agency runs afoul of interpreting a statute that's contrary to law, that's ultra virus, which I know your colleague's gonna argue. But it can't be the case that every time an agency goes outside the statute, that creates a new rule. So where's the line there? I mean, when does it become a rule? And in a situation like this where we don't have any evidence of this rule, we don't have an email, we don't have a checklist, we don't have anything that I could see in the record, what do we do with that?
It is an interesting question, Your Honor. So in our opening brief, actually page 70 and 71, there's an email that Mr. Troy Thwele's mother received from TDCJ staff stating, parole rules require your son to reside at least 500 feet from any school safety zone, such as school bus stops. And then he continues to say the school bus stop in question is within 500 feet and therefore cannot be approved. Another email that specifically page 71, I believe, Mr. Thwele's mother raised the issue with Appellee Hinojosa, who confirmed that the board is who imposed the condition. So we do believe that there is some evidence there. Further, there's testimony from the district court level that Mr. Partlow, when he was told that he's prohibited to live at the residence he proposed, while in prison, he saw his parole officer at the prison who showed him a map that had a sign indicating the location of a school bus stop that had a circle that was 500 feet around that sign. That circle intersected with the edge of his property line, he said, and then for that reason, he was told by this parole officer that he would not be able to reside at that address. So, again,
I mean, isn't our problem on the rule again? It could be one employee of TDCJ that decides, you know what, I think they shouldn't be near bus stops. We don't have anything showing us that the board has told TDCJ, you won't let them within 500 feet of a bus stop. You see the difference there. I mean, if it's one rogue employee, that's a totally different deal. But if it's the board actually saying, you will not allow anyone with special condition X live 500 feet of a bus stop, then we're talking, right? We've got potential for a rule. So do we know what happened?
So TDCJ's witness at the district court, a different person than sent this email, also testified that they always include these school bus stops. And again, that they only, their role is limited to investigating and supervising parolees. So they don't, TDCJ themselves does not, they're not the ones imposing the condition. So it is difficult, you're right, that it's difficult that we don't have the board affirmatively saying that this is a rule, you are required to do this, but everything else shows that it really is. If there's no discretion by the agency who is kind of enforcing the rules, supervising, investigating, being TDCJ, then everything else it's sort of either there's this unspoken practice, but
How would it work if this was a playground? So the playground is one of the listed examples in the statute. If people are looking and saying, that's a playground, that's a playground, that's a playground, would that be the board making that decision, or would that be the TDCJ? Like, I mean, here it just seems like everybody's kind of looking at the language of the statute and interpreting it. Would it be a different calculus if it were a playground at issue here?
right, yeah, so thank you for the question again. I do think the playground, that's sort of the issue here. It's very clear that the playground is included in the statute, but school bus stops aren't. They exceed the scope of what is in the statute. So what would happen in that situation is the board is imposing the rule, but again, that tracks with the statute, and then TDCJ is the person, or staff from TDCJ will come and say, hey, actually, there's a playground here, and so they would enforce it, but
Thank you.
Good morning, Your Honors. Norma Esquivel on behalf of the petitioner appellants. The government does not and should not have unfettered authority to unlawfully expand the definition of statutory terms for the purpose of controlling the lives of parolees living with special condition X. But the appellees have done just that by impermissibly designating school bus stops as a premise and therefore a child safety zone. This has resulted in the appellees rejecting parolees' housing plans only because the proposed residences are within 500 feet of a school bus stop.
Well, a premises includes real property, right?
That is correct, Your Honor,
And
yes.
Black's Law Dictionary says that real property includes land, right?
That is correct, Your Honor.
And a bus stop is on land.
Your Honor, that is exactly the argument that the appellees have proposed would designate a school bus stop to be a premises. But the issue there is that then there is no limiting principle. We have to look at the statute, which specifically incorporates the definition of premises from the Texas Health and Safety Code. But even
But wouldn't the limiting principle be where children ordinarily gather?
that, but it also must be taken in tandem with the totality of the statutory scheme, which says premises. So, Your Honors, I would like to, I believe we have.
It's a non-exclusive definition. It's including schools, daycare facilities, et cetera. Now, there's no question when the legislature does that, they mean they mean including but not limited to.
In other words, that this is a non-exhaustive list, correct, Your Honor? So defendants do assert that because this is a non-exhaustive list, that school bus stops must necessarily fall within the statutory definition of premises.
If they're a place where children commonly gather,
Correct.
which certain hours in the morning and afternoon would have to be true if it's a bus stop, right?
Correct, Your Honor, but we must also look within the statutory scheme, and I think actually the case of City of Madisonville versus Hernandez is instructive on this principle, because that too consisted of a statute at issue that contained a list of itemized premises or itemized recreational activities that the legislature did not intend to be exhaustive, but that were exemplary of what they contemplated when codifying that statute. And there they applied two statutory canons of construction. That's agistum generis and nocitur associus, meaning that you have to look at the class of the list that's itemized in the statute to determine whether the challenged act falls within the confines of the statute that the legislator contemplated. So here, so in City of Madisonville, for example, there the list of recreational uses was swimming, fishing, hunting, and the challenged action was whether flying an aircraft outside would necessarily fall within the statutory definition of outdoor recreational use. And there the court said no, because they looked at the itemized list, and in context of that itemized list, giving every word of the statute meaning and reading it contextually, whether a flying aircraft could conceivably fall within the list that the legislature intended. And there they said no. And that case is instructive here, because school bus stops, unlike an arcade, a playground, as Your Honor mentioned earlier, or a public pool, it is not a fixed, immovable premise. It is in fact something that moves constantly and does, even during a school year. So in the lower court, for example, testimony was elicited that oftentimes it's not even marked, there's no signage, and that it can be moved given any time of the year if a new need arises for school.
But the legislature didn't include a marked and unchanging, like those words aren't in the statute, right? You'd be asking us to read those into the statute.
It's more so that we are looking at the definition of premises that's specifically incorporated by reference into 508.225. So if I may, Your Honors, we handed over a packet consisting of some statutory language, and I'd like to go through that with you. So again, Texas Government Code Section 508.225 specifies that a child safety zone is a premises where children commonly gather. So it can't be read in a disaggregate manner, that it's either where children commonly gather or premises. It's premises where children commonly gather. And that falls in line with Texas decisional law when it comes to statutory interpretation. And premises within that same statutory scheme of 508.225 means real property, or incorporates specifically the definition of premises as codified in Texas Health and Safety Code Section 481.134 sub A4. And I'll just read that definition, which is premises means real property and all buildings and appurtenances pertaining to the real property. And appellees, as you also noted, cite to Black's Law Dictionary definition of property, real property, which is land and immovable property on land such as building. But what the appellees failed to do is incorporate the definition of land from that very same source, Black's Law Dictionary, and this is on the last page of the packet. Land, an immovable and indestructible three-dimensional area consisting of a portion of the Earth's surface, the space above or below the surface, and everything growing on or permanently affixed to it. So taking that definition, if we were to say that anything that exists on land must necessarily transform into land, and I'll give your honors an example, a city-issued trash can, for example, can then be considered land. There is no limiting principle here, and
Isn't the limiting principle where children commonly gather? And children don't necessarily commonly gather around a trash can, but children always commonly gather around a bus stop.
But a better example of what you're saying is a bus itself could be considered a child safety zone.
That is correct. My intent was more so to illustrate the extremes of how land law could fundamentally change if anything on land could then be considered land. But for example, if we were to think of other situations that is as movable as a school bus stop and has temporal limitations to it, as I just noted, school bus stops frequently change, a lemonade stand.
What happens then? If they move one to your house, do you have to move if you're a parolee?
So, Your Honor, at the lower court, Mr. Oda testified about his experience living with the school bus stop rule. And there he noted that his initial housing plan was approved. He was released with the intent of benefiting from the full benefits of being released on parole. And within 24 hours or so of being released, he was told, in fact, there is a school bus stop that is 500 feet within your house. You are now under house arrest, and we have to find you alternative housing, or you have to find alternative housing. So this is just illustrative of the kind of results that could happen if the government were to continue to have unfettered authority without checks and balances to designate anything that could conceivably be perceived as an area, location, more nebulous, broader terms than what the legislature intended as a child safety zone. So take, for example, someone who may have purchased property. They're on parole, they buy a house, and a school bus stop one day is placed within 500 feet of their home. What would the consequences there be? Most likely that they wouldn't be allowed to live there. Now,
Isn't there a process for them to challenge, short of us rewriting the statute?
yes, Your Honor, you beat me to it. So there is a process. There is a modification process that goes directly to the parole officer. But that's the problem. So my understanding of this process, by also representing some of the clients in this particular process and by the testimony elicited at the lower court, is that this is not a modification process that works because some people have submitted requests for modification to the parole officer, and the parole officer has discretion to elevate this modification or not with the board. They can summarily deny it, and they can approve it. There's nothing really binding them to saying, because there is a school bus stop and we don't want to deprive you of your property, we are going to allow you to stay there. So there doesn't appear to be a functioning system in place that actually takes into account the very real consequences and possible deprivations of property that could result if this conduct were to continue. So that's the problem here, again, is that all of this has to be taken within the context of the statutory scheme. And just to clarify how each of the parties have acted ultra vires here, because I think it is important to just set forth exactly how they're responsible. Gutierrez.
I want to just toss something, you're about to run out of time. That process for challenging, though, there's nothing in the statute that says you can't file a suit for review of that, correct?
That is correct, although the appellees have contended that lawsuits such as these are impermissible because of the modification process, and they also believe this to be a decision that is unreviewable because it's internal parole policy.
I mean, wouldn't that be an exhaustion of remedies argument that would have to be made?
Possibly, but I don't know if there is a statute or guidance on point that would require exhaustion of remedies here. Your Honors, I see my time has concluded, and I thank you for your time.
Thank you.
May it please the court. The district court properly granted Director Hinojosa's plea to the jurisdiction because the appellants failed to identify a waiver of sovereign immunity. Had they pled a valid or viable ultra-virus claim, the district court would have had jurisdiction, but that's just not the case here. As convicted child sex offenders, the appellants are all subject to Special Condition X, which imposes many restrictions. One of those is the child safety zone, which prohibits them from living within 500 feet of a child safety zone. Several of the arguments I had planned, Your Honors already brought up when opposing counsel was up here, but just to point them out, a child safety zone, the list in 508187 is not exclusive. It is not exhaustive. It allows for Director Hinojosa to determine that there are other child safety zones if they meet the definition of premises and if they are a place where children commonly gather. And this does not give them free rein to start establishing child safety zones everywhere.
But isn't that the problem? I mean, isn't that the problem of having it not be a strict requirement that these are truly places where they commonly gather, like the examples given in the statute? I mean, under y'all's definition, why couldn't a school bus be a child safety zone?
Your Honor, I don't believe that school bus meets the definition of real property, or of like land, of premises.
Right.
Yes.
But that's the point, it's on land.
The school bus is on land, yes. I mean, I don't know,
Structure.
hopefully it's on land.
Yeah, we have, unless we're in Seattle, maybe. But the other question is, what keeps, one of these offenders is in a home and a family moves in next door, and the evidence shows that that family has kids over all the time, and it's within 500 feet. That's a premises where children commonly gather.
It is, Your Honor, but I believe the difference is that that is a private home, and if you look at,
But where's that in the statute?
Your Honor,
If we're gonna just say this is anywhere on land where kids gather, if that's the definition, and that is the definition y'all put in your briefs, if that's the case, why isn't that kid's home a child safety zone within 500 feet of the offender's residence?
Your Honor, I mean, that is definitely a valid question, and I think if we were to read the statute like that, you would get some very nonsensical results. Because all of a sudden, if a family decides they want to keep having kids over, or they're going to babysit some friends' kids after school every day, then you would run into the problem exactly what you're talking about. All of a sudden, you could have all these little pop-up child safety zones.
I mean, school bus stops are similar. I mean, I drive in county roads to get here. The only reason I know I'm passing a school bus stop is I see parents' headlights sitting in the dark, waiting for the bus to come. And I know, because I'm married to a teacher, that they move. I mean, sometimes that bus stop, it's not great because the bus can't see the kids, or it's not great because in our situation where we have a lot of dirt roads, it gets muddy and potholes. So they move it. What do you do?
Well, Your Honor, first of all, most school districts, if you go online to their transportation department, you can actually find and locate where they have set the school bus stops. And yes, there may have to be some changes that are made throughout the year if there's construction, or say they have a lot of students in a certain place, they need to add an additional bus stop. But I'd like to point out, there's a distinction here between Mr., I'm not gonna say his name, Mr. Uda, where he was released, and within 24 hours they were telling him it was wrong. They noticed their mistake very quickly. Versus someone who, say, has lived at a property for quite a while, and now there's a new school bus stop that's added. That is a situation where they could go to their parole officer and say, I'm already living here, things are going well, I'm established, and I would like for you to consider taking this back to the parole board and saying, can I continue to live here? And that's a different situation than what Mr. Uda was in, where it was less than 24 hours.
Could you take on the argument that's made in the reply about section 508225 saying that someone under special condition X can pass through a child safety zone on their way to another premises, facility, or location? Because isn't the word location being used in that a problem for y'all's interpretation of the statute?
Yes, Your Honor, and I believe the reason that they chose to use premises was because the definition of premises is also specific to protecting children, and that it's found in the act that it's found in, and I don't know if I have the name of the act that it's found in.
But my point is, if you use location, and the only thing that makes it a premises, the only thing that would shift that to becoming a premises is that it's on real property. Does location just mean in the ocean or in a lake?
You know, that's a good question, Your Honor. I think the fact they use things premises, facility, or location, I think they're just trying to be all-inclusive there, and I think the big difference is that when you look at 508.225 or 508.187, the reason that perhaps the legislature did not want to give an all-inclusive list is because there were potentially other things that could pop up that should be considered child safety zones, and they didn't want to eliminate those. Whereas when you use, I'm looking at 508.187, B1, 5B, where it says authorized by the division as a premises, facility, or location. That is a limited list there, premises, facility, location.
But we know premises and location don't mean the same thing, right?
Right.
So what's the difference in a premises and a location?
Does a location require land?
I don't believe that a location does require land, because
there
you
is a
have a plane,
distinction.
airplanes are in a location as they're traveling.
So if it's air or sea, they can pass through.
I just believe location, it's like saying all thumbs are fingers, but not all fingers are thumbs. I think location is just larger than premises. If that analogy works for you. I think location is larger than premises.
And has this, I saw something in the briefing about the statute being interpreted to include school bus stops for 30 years. Is that correct? Is this the first time there's been a challenge to the statutory definition of premises, or?
Yeah, based on the testimony that was given at the district court, Your Honor, the individual for Texas Department of Criminal Justice, the parole board, said that when she began in 1998, this was already something that had been in effect. And so it has been quite a long time. If you look at case law, I was unable to find any other, say, Supreme Court of Texas or even Supreme Court of the United States cases that were on this topic. So is it possible that there's another, say, district court case out there? Maybe, but not that I found.
So we could have just been misinterpreting the statute for 30 years, everybody.
I mean, I suppose that's possible, but I don't believe that's correct. I believe that Director Hinojosa is appropriately interpreting the statute.
How do we know, how does someone who comes to either the board or the TDCJ know that this policy exists?
When you say someone, do you mean like a new employee?
Yeah, how would a new employee know, okay, I'm reviewing a parolee's living arrangements, how would they know that this rule exists, or this policy, or whatever we wanna call it? I don't wanna call it a rule, because that goes into one of their arguments.
So something that Texas Department of Criminal Justice is great at is is writing out policy and making it very specific and clear. And there's policy for almost anything that you could think of. And the Texas Department, bless you, Texas Department of Criminal Justice. And there is a policy for this as well, and it is in the record. There's also another policy, 3.6, I want to say, that's not in the record. And it goes through screen by screen, telling them exactly what do you look for, where do you enter this in the computer, what are the options going to be. So there is training that they would receive, and there is specific written out policy that would walk them through this. Are there any other questions I can answer?
Thank you.
Thank you.
Rebuttal? Oh, I'm sorry. Didn't mean to rush you.
May it please the court. Good morning, Your Honors. Rosalind Hunt for the board. We're asking the court to affirm the trial court's order granting the plea to the jurisdiction because the legislature has not waived sovereign immunity for any of the appellant's claims against the board. You've talked a great deal about the bus stop rule, and it is correct that you can't assign that rule to the board. The board doesn't have a bus stop rule, a policy, a practice, or interpretations. And also, the appellants do not have an injury that's redressable by declaratory or injunctive relief against the board. For a couple reasons, we don't have a bus stop rule. One is because the board's policy states verbatim the statutory language describing a child safety zone, which we've covered. And the second part is, as a practical matter, when the decision is actually made to deny that housing plan, and that's made at the divisions level by the parole officer, not the board. But
So you're saying, I think, that it's the TDCJ. If anyone's got liability here, it's TDCJ, not the board?
yes, Your Honor.
Okay. But at some point, the determination is made by TDCJ on the conditions of a parolee's housing. Don't they come back to the board for final approval?
So the process is the releasee has to provide a plan to the parole division that includes where they're gonna live, and the parole division investigates the location and makes sure it meets all the requirements. And when they decide to approve that housing plan, they don't have to go back to the board. Now, I think it is important to know that the decision of the parole the division is reviewable by the board, because if the paroled inmate does request modification, that can come back to the board to modify the child safety zone as applicable to them. And the modification procedure is important for a couple of reasons. One is because this is the pathway the legislature set out for the inmates to challenge their child safety zone to have that modified, not through this type of lawsuit. Because each of these agencies has very strong sovereign immunity that protects them from this sort of lawsuit. And another key thing about the modification procedure is it provides in statute at any time after the imposition of a condition under subsection B1, the releasee may request the parole panel to modify the child safety zone applicable to the releasee.
Are y'all making an exhaustion of remedies argument? Because I didn't see that y'all made that claim below.
No, Your Honor, this is not an exhaustion remedies argument because this isn't an administrative appeal. What they have brought,
Prerequisite to filing suit, then you don't have to go through the modification proceeding before you file suit on an ultra-virus claim. Or am I missing something?
correct. It's not an exhaustion requirement. What it is it's a pretty clear indication that the legislature said, hey, don't file suit here. Instead, request for modification of the child safety zone. And it's not impossible or one of those remedies that's not available to them. I would disagree strongly with appellants. There are examples of it working in the past. The board had a parole inmate come to them, and a nursery was being opened in a house right across the street from this inmate. And he went to the board and asked for modification of the child safety zone so he could continue to live in that residence across from the nursing home, and the board approved that modification.
Did you say a nursery or a nursing home?
It was a nursery.
And so this was an in-home nursery?
It was a nursery, and I think that's another example of how you kind of have to interpret that list, because the list also includes a daycare.
And that
You
could
know.
be an in-home daycare?
The list says daycare, but they gave the exception for nursing home. So I think there's some flexibility on both sides. And I think there's an opportunity for the board to consider these facts as applicable to the individual. Some of the factors considered for modification are, is it broader than necessary to protect the public given the circumstances of the offense? And I think that's written perfectly, because you have one half that says, are we protecting the public? And the other half considering what is the offense, the nexus of this child safety zone to the crime. And the offense was sex offenses with children. So that's the public safety aspect
We
of it.
don't necessarily have to carve bus stops out of the definition of premises or land, in order for there to be an evaluation of whether this person really shouldn't live next to a bus stop.
I think that there's another pathway, and so, we're not taking a position on how the division interprets that policy, but there's another pathway to have some flexibility as it comes to a particular inmate in that modification process. But I think the premises argument, we wouldn't say it's germane to our position, because our position is we don't have a rule. But the statutory list also includes things that are movable and more flexible. Take a playground, for example. That could be constructed in under a day. You put a swing set on a vacant lot, a little whirly wheel, and you have a playground. That can come up and down. You could put it at an apartment complex. You could put it on a vacant lot. So I don't think the move,
If, like my sons used to do, they took bases and a wiffle ball bat and a wiffle ball and stuck them in the street outside someone's home, then we have a child safety zone?
I think the point is, Your Honor, that doesn't make it a rule, right? That makes it
No,
an.
I'm not talking about the rule. I'm talking about just pure statutory interpretation. My kids regularly putting bases and a wiffle ball bat and a ball so that all the boys and girls from the neighborhood come play wiffle ball in front of the parolee's house. That's child safety zone.
Let's say with your example, that's a playground, right? Or a baseball field.
Well, but the question is not whether it's a playground, whether it's a premises.
I think what you're hinging on is something that's important. So a division employee, a parole officer, there's judgment involved. There's discretion involved. I think that's the key, because here they are looking at a child safety zone. They have this list, and they're trying to decide what is the best thing for the public and to ensure that this inmate, this paroled inmate, has the best chance of success to not reoffend. So they're looking at this list, and they're making a decision each day about
But let me
is,
stop you for a second. There's a difference in ultra vires law between absolute discretion and regular discretion. Are you saying that the parole division has absolute discretion to interpret the statute?
I would say that they have discretion. It's not our argument to make. Because
Well,
there's,
it is. I mean, actually, it is. I mean, we have Hall versus McRaven, and we have Houston Belt that draw this distinction between absolute discretion and other, I don't even remember what they call the other type of discretion, just normal discretion. So it is y'all's argument to make. If you're saying that because we have discretion, you can't challenge whether this is a child safety zone, that's absolute discretion. So that's what I'm asking you. Are you taking that position?
the board, no, Your Honor, I can't answer that question for the division. And I think this is still significant because there's been created some confusion about the distinction between the division and the board. They are two different state agencies. The board is an agency that's created under the Constitution as well as statutory authority. And it's not the board's place to tell the division how it is supposed to implement its statutory authority. So because the board, our chairman, Chairman Gutierrez, did not make a, bus stop rule, we didn't expand the statutory definition of child safety zone, it's not our position to defend. So with that, Your Honors, I'll just conclude with, we would ask you to affirm the trial court's order granting our plea to the jurisdiction, thereby respecting the legislature's codified procedure for modifying a child safety zone.
Thank you.
Thank you.
Brief rebuttal?
Your Honors, 2 points on rebuttal. So the first is we discussed the distinction between premises, facilities, or location as they are disaggregated in the relevant statutes here. I want to illustrate or provide another illustrative example of what could conceivably be deemed a location, something like a funeral. And in fact, a funeral is used as an exemplar of what a location could be within the statutory scheme. So location cannot swallow the term premises or facilities. It cannot be used interchangeably with premises or facilities. Premises is limited, and the legislature had good reason to limit it. It's to ensure that the government doesn't continue to have a blank check in determining what constitutes a child safety zone and what doesn't. And Your Honors, I would also like to speak about the fact that we don't need an explicit waiver of sovereign immunity here, because ultra vires acts are not considered acts of the state, and that's from Cobb versus Harrington. So that is not,
But it's only ultra vires if it's beyond your statutory authority. And here we've got a statute that says premises where children commonly gather, including X, Y, and Z. Yes, I can imagine cases where children do not commonly gather in a place, and that would be an ultra vires claim. It does not seem to me that a bus stop is clearly not a place where children commonly gather, and so that's a discretionary call. And how is that they have authority to decide where children commonly gather in particular cases. How can this be an ultra vires claim?
so one moment, Your Honor. I would note that the word place was used, right? And I know that that's just to illustrate again that a school bus stop is not the type of premise that was contemplated when the legislature was codifying the statute. And that's again because premises has a really limited definition, correct? I see my time has expired.
briefly.
May I briefly conclude? And just to go back into the relevant.
My question was, that calls for discretion. There's definition, children commonly gather, and you can get beyond that, but if you don't get beyond that, that's their limited discretion. And so if a school bus stop, under the facts of this case, fall within that, it can't be ultra vires, can it?
If the determination is that a school bus, if Your Honors decide that a school bus is a premises, or school bus stop, is a premises, then it would not be ultra vires. But I would argue again and submit.
Just the premises.
That's correct, Your Honor. If Your Honors don't have any further questions, I will conclude.
Very helpful.
Thank you very much for your time.
Thank you. We'll take a 5-minute adjournment. Be seated, please. Call case number 1524-00054, Health and Human Services Commission versus Navarro. For the appellant,
Good morning, Your Honor. Appellant, HHSC, Joseph Keeney.
splitting your time, Mr. Keeney?
I'll be reserving 5 minutes.
Okay, and splitting or one speaker for appellees?
Good morning, Your Honor. Mike Lostenberg for the plaintiff, just one speaker for the appellate.
Good, thank you. Mr. Keeney?
Good morning, and may it please the court. The sole issue in this appeal is whether the court lacks subject matter jurisdiction and should dismiss this case under the state's sovereign immunity. There are 3 primary reasons why Chapter 260A of the Health and Safety Code does not waive sovereign immunity. First, there is absolutely no statutory language, no word nor phrase, that clearly and unambiguously expresses legislative intent to authorize suit against the states. Second, whether a state-supported living center falls under the definition of a facility under the statute makes no difference. Even if it did, though it does not, that would not be clear nor unambiguous language. And third, for the court to accept Navarro's radical position in this case, it would have to reject decades of well-settled jurisprudence and create an entirely new basis for waiving sovereign immunity out of whole cloth.
Did Navarro have another remedy here? If we find that there is no waiver of sovereign immunity, is there something else Navarro could have done?
Under the particular fact pattern, as alleged at least, there was no discovery at the trial court, but at least taking the factual allegations as pleaded, Navarro alleged she did not report abuse and neglect to an appropriate law enforcement authority. If she had, she would have had a remedy under the Texas Whistleblower Act in Chapter 555 of the Government Code. The legislature is in the best position, and I'll go ahead and address this point.
Obviously, the troubling thing is if you've told people, if you see anything going on, call this hotline. She calls the hotline. Aha!
Mm-hmm.
You've lost because you didn't call the state troopers. I mean, at some point, that can't have been what the legislature intended.
Well, as far as reporting to the hotline, as far as reporting to the Department of Family and Protective Services, that I believe would be a report to an appropriate law enforcement authority.
The hotline is law enforcement?
The hotline, well, assuming we're talking about the correct phone number, the hotline to the Department of Family and Protective Services would be to an appropriate law enforcement authority. It is rather the report to a supervisor that would be the activity that would not be protected under the Whistleblower Act.
If you report it to your, assuming the supervisor is not involved, they tell you to report it to your supervisor, then they're home free.
If they're instructed to report to the supervisor, well, I think the important point is that employees at state-supported living centers are directed and are required, they are mandatory reporters, so they are required to report to law enforcement authorities. And that is a condition of employment, so they can be terminated for that failure. It is not simply enough to report to a supervisor. One is entrusted with the knowledge and the expertise to know what should be directly reported, and I think there's some timing.
Where is that in the record? I'm sure I missed that. As a condition of employment, they have to report it to law enforcement?
That was not in the record, Your Honor, but I'm happy to provide some supplemental briefing on the policy that is found in their employment arrangement with the employers at El Paso State.
So your position here is that the statute in question has no waiver of sovereign immunity, the one that we're here under?
Chapter 260A, yes. Returning to the central question here, Chapter 260A provides no basis for suing the state. There is no waiver of sovereign immunity under that statute.
Do we know, are all of these facilities owned by the state?
State-supported living centers are owned and operated by the state. There are a number of private facilities, which I'll address in a moment, that Chapter 260A applies
Also
to.
governs.
Okay.
What's
So not all, in other words, even if this facility met, I know I'm using the term that's in the statute, but even if this met the definition of facility, not all facilities are owned by the state.
Not all facilities, yes, Your Honor, and the definition of a facility in Chapter 260A incorporates by reference 3 other definitions in other statutes. So Chapter 242 defines an institution, Chapter 247 defines an assisted living facility, and Chapter 248A defines a prescribed pediatric center. An institution, I should note, well, let me jump ahead. The appellee argues that the state should have expressly exempted state entities from the definition of a facility in Chapter 260A. Well, that exemption language is not in Chapter 260A, but it is in Chapter 242 and 247. This is the type of language that Navarro expressly argues shows that the legislature was not intending to waive sovereign immunity. Accordingly, Navarro has inadvertently admitted that a state-supported living center, just simply by the definitions, cannot be an institution or an assisted living facility under Chapters 242 and 247. That leaves only a prescribed pediatric center. A prescribed pediatric center provides non-residential treatment, whereas a state-supported living center provides residential treatment. And since the state entities can only exercise what authority they have that is granted to them by the legislature, there cannot be any overlap. Residential treatment is the only type of service that is provided by a state-supported living center. So accordingly, a facility cannot encompass a state-supported living center. This is the only, I should note, this is the only textual argument that the appellee raises. Only text can express legislative intent, not the absence of it, and not any other concern like a policy concern. But the type of text here, at most, would be ambiguous. In Wichita Falls State Hospital versus Taylor, and then affirmed later that, I believe, very year in Center for Healthcare Services versus Quintanilla, the Texas Supreme Court considered a very similar statute that incorporated by reference a definition of suable entities, like the statute at issue today, that included both private and public facilities. And in that case, in both of those cases rather, the court found that for 2 reasons, 2 primary reasons, the ability to sue both private and public facilities, the ability to sue private facilities would render the statute not meaningless if one were to construe the statute as not allowing suit against the state. In other words, the statute could not be rendered meaningless if one found no waiver of sovereign immunity because there was still a viable right of action against private facilities. Further, under the second canon or aid of construction articulated in Taylor and Quintanilla, this language, incorporating by reference other statutes with lists of potentially suable entities, at best inserted ambiguity into the statute that was argued to waive sovereign immunity. Ambiguity is always resolved in favor of the state and against finding a waiver of sovereign immunity.
What do you do with the argument that there's an ambiguity because when you look at section 21.004, that has an exemption that says this chapter does not apply to a facility maintained or operated by the state or an agency of the state. Do you need something like that here?
You do not need express language that states that sovereign immunity is being retained or that this chapter does not apply to the state. In the absence of any such language, you use simply the guide, the test articulated in Taylor and Quintanilla. You use those 4 canons or aids of construction. You're in the same boat as if the statute lacks, and oftentimes it will, lack express language stating sovereign immunity is waived. In either case, under either direction, you use the same analysis. And that is because omitting language, legislative silence, cannot express an intention to waive sovereign immunity. There has to be the action, there has to be the expression in order to find a waiver. If you would look at the Code Construction Act, there is a presumption against a waiver of sovereign immunity. Because of that legal presumption, I believe it was argued in the appellee's brief that we had the burden. That presumption forecloses any notion that we had the burden as a matter of law of showing that there was a no waiver.
Could I ask about another argument that Navarro makes? The argument is that generally the legislative intent behind Chapter 260A is to protect residents of facilities from abuse, neglect, and exploitation, and this would be undermined if there's immunity.
I'm glad you brought up that point, because as an initial matter, I should note that the ephemeral policy, the unarticulated, unstated policy behind a statute simply is not statutory text, so we can disregard it at the first step. Further, it is a mere assumption that I'll address in a second is incorrect. It is a mere assumption that residents at state-supported living centers would be left unprotected if one public employee could not file suit under this very particular statute. Not only are residents at state-supported living centers protected, well, by the by the public employees that work there, they are also protected by the Health and Human Services Commission's Adult Protective Services, which conducts investigations, and we cited to the Human Resources Code that talks about these investigations. Conducts investigations in state-owned entities to root out and ferret out any notion, any evidence of abuse and neglect. Moreover, as I've already discussed, the Whistleblower Act, to the extent that the employment status of a public employee furthers the interest of protecting residents, whether at public or private facilities, they are protected under the Whistleblower Act. The legislature has weighed competing interests and made the policy determination to prescribe a cause of action under the Whistleblower Act. It is not, as discussed, it does not encompass reports to supervisors, but it does provide a method of protection that Navarro could have taken advantage of had she reported as directed to law enforcement. I see my time is almost to an end. I'd like to conclude simply by noting that what should already be readily apparent, and that's that if the court were to affirm the trial court, it would constitute a wholesale rejection of, and reasoning, a rejection of all the reasoning and precedent of every single Texas Supreme Court opinion to have considered this issue over the last 2-3 decades. Since 2006, in Tuke versus City of Mejia, the court has consistently refused to even entertain implicit waivers of sovereign immunity. The last time the Texas Supreme Court did find a waiver of sovereign immunity on a particular statute was in Kerrville State Hospital versus Fernandez in the year 2000. In both that case, as well as City of LaPorte versus Barfield, which my friend has cited, there was explicit reference to a government entity, a city in LaPorte versus Barfield, and state entities in Fernandez. Thus, there was clear and unambiguous legislative language, statutory language, that one could ground a decision waiving sovereign immunity. There is no such phrase, no such word in Chapter 260A upon which to justify such a ruling. The legislature knows how to waive sovereign immunity. It can do so with express language. It can do so implicitly with clear and unambiguous language. There is none such in this statute. For that reason, we respectfully request the court to overrule, to reverse the trial court and dismiss this case with prejudice for lack of sovereign immunity. I'll reserve the remainder of my time unless there are any further questions.
Thank you, Mr. Keeney.
Thank you.
Mr. Osterberg?
Good morning, Chief Justice Brister, Justice Field, Justice Ferris. My name is Michael Osterberg. I'm here for the plaintiff in this case, the appellee in this case, Kathy Navarro. Thank you for having us, and thank you for your time this morning. So this case is not about one public employee. It's not about one report that she made. This is about every employee that stands in the shoes of Ms. Navarro, who works in a state-supported living center, who sees abuse, who sees neglect, who sees exploitation, whose job should be protected when they make a report of abuse, neglect, and exploitation. And it's not just for Ms. Navarro or the other public employees who stand in her shoes, but it's for the victims of this abuse, for the victim of this neglect. A finding that the state of Texas has sovereign immunity in this case would devastate the protections given by the legislature to that vulnerable population. And in providing a retaliation cause of action for an employee terminated in response to her report of abuse, neglect, or exploitation, by doing so, the legislature expressed its intent to protect these voiceless populations and by protecting the employees who report the abuse.
Why doesn't the Whistleblower Act work for that here?
So the Whistleblower Act requires a report to law enforcement. In this case, Ms. Navarro reported to her supervisor. And it was the final report that Ms. Navarro made that it was essentially the next day she was terminated. But months prior, she had made a call to the hotline, and she was told in no uncertain terms by her supervisor, do not call that hotline, you come to me. And so that is what Ms. Navarro was operating under, where she saw something that she believed was abuse, neglect, or exploitation. She was working as a dental hygienist in the El Paso State-supported living center. Other hygienists were attempting to do x-rays on a 60-year-old wheelchair-bound patient with the mental capacity of a 2-year-old, and they started to restrain him in a way that she believed was violative of the policies at the living center. She asked them to stop. They didn't. She reported it to the dentist under whose supervision she was working, who wasn't in the room at the time, and the next day she was fired.
But the whistleblower statute has been under attack for at least 20 years by people saying law enforcement authority is too restrictive. And Texas Supreme Court repeatedly says law enforcement means law enforcement. You want a broader waiver than that, you're gonna have to go to the legislature, and the legislature hadn't done it. This seems like kind of a backdoor way to expand the whistleblower statute against the state, and something that mostly applies not to the state, but to other facilities. And if that's what they intended, that's perfectly fine, but wouldn't we expect them to do it more clearly?
Your Honor, and there are cases that talk about this. Even in the Wichita Falls versus Taylor case, the Supreme Court there specifically said there are no magic words required to find a waiver of sovereign immunity, and the statute need not be a model of perfect clarity. I assume if the legislature was a lot better at writing statutes, a lot of us would have a lot more free time on our hands.
That's what the courts say, but what the legislature says, it has to be clear and unambiguous. And, sometimes judges don't feel comfortable with these things, and they may kind of slide around them, but, it's not what our oaths we're supposed to do.
I think the courts reflect your expression there. Like not only in the Wichita Falls case, they talk about, well, there doesn't need to be this magic language. In the Kerrville case, they state that the clear and unambiguous requirement is not an end in itself, but merely a method to guarantee that the courts adhere to legislative intent. And I think in this case, the legislative intent, to me, is very clear in the title of the chapter, Reports of Abuse, Neglect, and Exploitation. That is a statute enacted by the legislature to protect the residents. And how do we protect them? We tell the employees there's a criminal penalty if you don't report abuse, neglect. We also tell the employees you can't be fired if you report abuse and neglect. And so putting an onus in the chapter, putting an onus on the employee that you have to report instances of abuse, neglect, and exploitation But allowing the state to then fire the person for making that report, it doesn't make sense, and it's just not coherent.
I see that, but the 260A009 says Ms. Navarro would be immune from civil and criminal liability because she reported to a supervisor, if that includes her in .014. So we would have a clear waiver of criminal and civil liability against her, but not against the state. Is there other places where immunity is in here other than the, there is the cause of action. She's got a cause of action, but again, a cause of action does not waive immunity. You gotta have that separate.
Right, I agree, and I think those two things you mentioned actually work together. So if she doesn't report it, if she knows of abuse and doesn't report it, then she's can potentially be criminally charged.
Right.
But she cannot be criminally charged if she does report it. Like she can't, and I think maybe that goes to like, you know, defamation or some other thing where it's like, well, you accused me of X, Y, and Z, which is horrible, but she can't be sued for that. And the criminal immunity she has for making a report it works right together with the criminal liability she has if she doesn't make a report. So those two things aren't opposite. Those two work together.
And I'm sorry, go ahead. And you're in agreement that the word facility can refer to either state or private entities?
Absolutely, absolutely. I don't think there's anything in the definition that would preclude including state facilities in here. And as you pointed out during my friend's argument, the legislature knows how to exempt state facilities from those types of definitions, and they chose not to here.
Do you agree that, the bottom line analysis on sovereign immunity is whether the statute would be rendered meaningless if we took state agencies out of it? Is that the standard? And if so, do we have that here?
I wouldn't call it the bottom line or the ultimate issue. I think it's a factor among several as Taylor points out, it's a factor among several to consider. In Taylor, they talk about whether or not the statute would be pointless if they find sovereign immunity or if they don't find sovereign immunity. In that case, they talked about going back into the legislative history and that statute was specifically directed at private facilities. And the legislative history indicated that the private facility and what was going on in private facilities was what the legislature had in mind. I didn't find anything similar in this instance. And like we pointed out in our brief, the state has no less an interest in ferreting out abuse, neglect, and exploitation in their own facilities than they do in private facilities. And that's what the purpose of this statute is, I understand my friend saying, they've got all these investigative arms and ways to find abuse and neglect, but the type of abuse, neglect, and exploitation that happens in state-supported living centers or any center, private or state, where there are vulnerable populations, maybe pediatric patients, the elderly, the infirm, 60-year-olds with the mental capacity of 2-year-olds, abuse, neglect, and exploitation of that population only comes to light through whistleblowers. It only comes to light through employees who are courageous enough to speak up. And the legislature wants to protect those employees by saying, listen, you can make the report and you won't lose your job over it. And like I said before, the idea that they can put a criminal penalty on her to say, if you don't report abuse, neglect, or exploitation, we can throw cuffs on you. But if you do, we're allowed to fire you in retaliation. It's just incoherent, and that's where we go back to the legislative intent. There's no way that the legislator intended such a result in this case. And like I said before, we all know that legislatures don't always write the clearest statutes, but the courts have already made room for that. The Texas Supreme Court has made room for a court like yourselves to make interpretations that are consistent with the legislative intent, allowing for the fact that we don't need magic words. It doesn't need to be a perfectly worded statute. Really, you can use your common sense to say, look, it doesn't make sense that we could criminally penalize someone for not exposing abuse, but then fire them in retaliation for exposing the abuse. And the statute makes a lot of sense to include this cause of action. And there's really no reason not to apply it to the state. They're not excluded from any of the definitions. They are certainly an institution under this case. And like I said, it's not just about Ms. Navarro or the report she made or her job. It's about the pediatric care facilities that this applies to. It's about the assisted living homes this applies to. It's about the state-supported living centers across the state of Texas. And in my brief, I mentioned that on the Health and Human Services Commission's website, you can find the populations of these state-supported living centers in Texas. This is over 1,000 people just in the state-supported living centers, without getting into pediatric care facilities, without getting into other assisted living centers. There are over 1,000 patients in the state-supported living center system across Texas that will be affected by this. And all of the employees that work in those facilities, who are the eyes and ears for the legislature. That's why the legislature makes a cause of action like this.
Could I ask you one question about something your opposing counsel raised, just in terms of burden? So who has the burden when there's a state entity involved of demonstrating a waiver of sovereign immunity?
Your Honor, I think since it's purely a question of law, there's no facts at issue here. We're purely interpreting the statute. I think whoever the burden falls on, the question is, did the legislature intend to, we all have the.
It's a legal issue analysis.
Right, it's just a legal issue analysis, yeah. And the question is simply, did the legislature intend for the state to get a free pass to fire in retaliation employees who, in compliance with their legal duty, on pain of criminal punishment, make a report of abuse, neglect, or exploitation that they witness? That's the question here.
Any other questions? Thank you, Mr. Osterberg.
Thank you so much.
Briefly, Mr. King.
Thank you. Just a few brief points I'd like to make. I want to clarify that as a general matter, a facility can encompass both private and state entities, but as a matter of definition in Chapter 260A, facility, as it's defined, can only refer to private entities. By incorporating Chapters 242 and 247 and 248A, all of which expressly apply only to private entities, there's just simply no basis to find that a facility under the statute applies to a state-supported living center, as I've discussed when I was up here before. That, as far as policy is concerned, defeats all of the arguments that my friend has raised regarding, she would be put in handcuffs if she reported to a supervisor, she would be threatened with civil liability if she reported to a supervisor and then was fired, simply because Chapter 260A does not impose upon her any obligation to report to supervisors. Her obligation to report to law enforcement authorities is found elsewhere.
So are you saying, just taking that to its logical conclusion, are you saying that because it doesn't apply, if she makes this allegation to a supervisor, she could actually face criminal liability or civil, like she wouldn't be exempted because the statute doesn't apply?
It wouldn't be the fact that she had made the report to her supervisor that would put her in danger of criminal liability. Criminal liability does not come into play at all because we're talking about the Whistleblower Act and her obligations under the terms and conditions of her employment and the obligations under the Whistleblower Act. 260A's criminal liability is not applicable to employees at state-supported living centers. Further, again, these are all policy arguments. As we've discussed, sovereign immunity is not always fair, and the legislature has oftentimes considered whether to expand the Whistleblower Act. I agree completely that this is simply a backdoor way of raising a policy argument and expanding the scope of liability, exposing the public treasury and state entities to additional lawsuits that they would be forced to defend and divert other resources to instead of conducting other state business. These are the concerns that in Neighborhood Centers Incorporated versus Walker, the court said were exactly within the realm of the legislature to consider. Just because a policy, public welfare, for example, as expressly stated in Walker, just because a policy might be furthered by expanding whistleblower protection does not indicate whatsoever the legislature's opinion on whether or not it wishes to allow suits against it. With that, I have, unless there are other further questions, I have nothing to add.
Thank you, Mr. Keeney.
Thank you.
Bailiff will adjourn the court.
All rise.